consolidated case. Mr. Turner.
Thank you, Mr. Chief Justice, and may it please the Court. When Congress amended the Medicare Act in 1986, it put EMTALA on a centuries-old foundation of state law. States have always been responsible for licensing doctors and setting the scope of their professional practice. Indeed, EMTALA works precisely because states regulate the practice of medicine. And nothing in EMTALA requires doctors to ignore the scope of their license and offer medical treatments that violate state law. 3 statutory provisions make this clear. First, Section 1395, the Medicare Act's opening provision, forbids the federal government from controlling the practice of medicine. That's the role of state regulation. Second, Subdivision F in EMTALA codifies a statutory presumption against preemption of state medical regulations. And third, EMTALA's stabilization provision is limited to available treatments, which depends on the scope of the hospital staff's medical license. Illegal treatments are not available treatments. Add in this Court's own presumption against preemption of state regulations, combine that with the need for clear and unambiguous spending clause conditions, and the administration's reading becomes wholly untenable. The administration's misreading also lacks any limiting principle. If ER doctors can perform whatever treatment they determine is appropriate, then doctors can ignore not only state abortion laws, but also state regulations on opioid use and informed consent requirements. That turns the presumption against preemption on its head and leaves emergency rooms unregulated under state law. It's unsurprising that no court has endorsed such an expansive view of EMTALA. And until Dobbs, nor had HHS. Everyone understands that licensing laws limit medical practice. That's why a nurse isn't available to perform open heart surgery, no matter the need, no matter her knowledge. The answer doesn't change just because we're talking about abortion. The Court should reject the administration's unlimited reading of EMTALA and reverse the district court's judgment. I welcome the Court's questions.
Normally, when we have a preemption case, there's some relationship between the parties. Is the state being regulated by the federal government under EMTALA, or is the state engaged in some sort of quasi-contractual relationship?
Yes, Your Honor. In this case, the state, Idaho, for example, has no state hospitals that participate with the emergency rooms in EMTALA. And so in this case, there isn't even a quasi-relationship. The parties being regulated by EMTALA here are hospitals and doctors. And I think your question is getting at the Armstrong issue. And we think that is a significant question. It wasn't part of the question presented. We think the Indiana amicus brief raises significant questions and deals with that argument well. But the question presented here is one of direct conflict between Idaho's law and EMTALA. And on that question, we don't think it's hard at all.